Families and the law. Financial support. Family law in Alberta is complicated, but learning about the law that applies to your situation is a very good first step. This video is one in a series that talks about different parts of family law in Alberta. This video focuses on financial support when a relationship ends. Let's start with child support. What is child support and why is it important? Child support is money paid by one parent or guardian, the payor, to another parent or guardian, the recipient, for the support of the child. It is usually paid monthly based on a set formula. All parents have an obligation to provide financial support for their children. This obligation exists even if the child does not live with that parent. It exists even if the parents are not married to each other or if the parents do not have a relationship with the child. It exists if the parents live in another province or country. Child support is the right of the child, not the parent receiving it on their behalf. Who can apply for child support? You can apply for child support if you are the parent or guardian of the child. You can apply if you have care and control of the child. The child can also apply. You can apply under the Divorce Act or the Family Law Act, depending on whether you are divorced or in the process of getting divorced or not. Who has to pay child support? You must financially support a child if you are the biological parent or adoptive parent, if a court order names you as a child's parent, or you are an adult that has acted like a parent to the child, such as a step-parent. It's up to the judge to decide if a step-parent or other adult should pay child support for the child. How do you calculate child support? Child support is made up of two parts, the basic amount and special expenses. The basic amount of child support, which is also called the table amount or the Section 3 amount, is meant to cover basic living expenses for the child. It is calculated using either the federal or provincial child support guidelines, which in Alberta are the same. The table amount is based on the number of children and the gross annual income of the payor. The basic amount is mandatory, and there are very limited exceptions when it won't apply. Special expenses are also called extraordinary expenses or Section 7 expenses. These are expenses that are not basic living expenses. These expenses include things like extracurricular activities, post-secondary education, or unexpected medical expenses. Parents usually share these expenses in proportion to their incomes. For example, if one parent makes double what the other makes, and a $300 special expense, such as a medical or dental premium emerges, the higher income earning parent would be responsible for paying $200 of that expense. How is child support calculated? Several elements go into the child support calculation. First is the question of whether the children are entitled to receive support. All children under age 18 are entitled to child support unless they are no longer under their parents' care. This could be because they are married or in an adult interdependent relationship. Children 18 and over may be entitled to child support if they're a full-time student or cannot support themselves because of a disability or illness. Another important question is, what are the parenting arrangements? Where do the children live? Do the children live with one parent more than 60% of the time in a year? This is called primary care to one parent or sole parenting. Do the children live at least 40% of the time with each parent? This is called shared parenting. Or do some of the children live with one parent most of the time while others live with the other parent? This is called split parenting. A third question is, what are the incomes of the parents who are paying child support? This can be an easy task if the parent only earns employment income. But it can be more challenging if the parent owns a business or earns income from many sources. Once child support is calculated, can we change it? You can ask the court to change a child support order if new and important evidence comes up that wasn't available when the original order was made, or if the circumstances of one of the parents has changed. For example, one parent could now be making a lot more or a lot less money. Another example is that there has been a change in the parenting arrangements. What happens when one parent fails to communicate income changes to the other parent? Sometimes a judge will order retroactive child support. This happens when a judge orders a parent to pay child support now to make up for not paying the proper amount of child support in the past. It depends on the circumstances of each case, whether the person requesting child support has a reasonable excuse for why they did not ask for child support earlier. It depends on the behavior of the payor, and it depends on the circumstances of the child. What if someone is not making full payments or is not paying on time? If you are the recipient of child support, you can register your child support order with the Maintenance Enforcement Program, often called the MEP. The MEP can enforce an order if the payor is not making payments in full or on time, or if the payor has not made payment arrangements with the MEP. The MEP can also collect payments in different ways. Remember, you cannot stop your children from seeing the other parent, even if they are not paying child support. What if payments are overdue? When child support payments are overdue, the child support is said to be in arrears. When child support payments are in arrears, a judge can order the payer to pay the full amount, they can order a change in the amount, or they can cancel the child support payment altogether. But judges are very hesitant to change or cancel the amount in arrears. There would have to be a really good reason why the parent should not have to pay. Usually, the judge will postpone the payments or allow the payer to pay the amount they owe over time instead. Now, let's look at partner and spousal support. What is partner support or spousal support, and who can apply? Both partner and spousal support are paid after a separation or divorce if a partner or spouse proves they should receive it. It is paid by the partner or spouse who makes more money, the payor, to the partner or spouse who makes less money, the recipient. It's usually paid monthly. Partner support is only for couples that are or were in an adult interdependent relationship, a type of unmarried relationship in Alberta. You can apply for partner support under the Family Law Act. Spousal support is for married or divorced couples. You can apply for it under the Family Law Act, or if you have already filed for divorce, you must apply under the Divorce Act. The following information applies to both partners and spouses, so we'll just be using the term partner from this point on. What is the purpose of partner support? Sometimes a partner faces financial advantages and disadvantages because of the relationship or separation. Goals of this support include making sure that neither partner suffers economic hardships because of the separation, that they share the financial costs of children between them, and to promote each partner becoming self-sufficient within a reasonable period of time. A judge can order partner support when one partner has stopped working to raise the children and so has no income when the relationship ends, or when one partner needs to go back to school to learn new skills to be able to support themselves in the future. How is partner support calculated? You and your partner can agree if and how much partner support will be paid. If you and your partner cannot agree, then you can ask a judge to decide. A judge will consider the income of the payor and the financial need of the recipient, and both partners will need to submit income information and budgets to the judge. In Alberta, judges use the Spousal Support Advisory Guidelines as a starting point. These guidelines are not law, but they do give a range of what partner support could be. How does a judge decide on partner support? Not every partner is entitled to receive support. You must prove that you should receive it. If you cannot prove it, then the court will not make an order for support. The judge will consider many things in making this decision. Things like, how long have the partners lived together? Did one partner work while the other partner stayed at home? Is there any agreement or court order between the partners? How much does each partner earn? What happens if someone has been ordered to pay partner support but doesn't pay? Just like with child support, you can register your partner support order with the Maintenance Enforcement Program, MEP. The MEP can enforce an order in different ways if the payor is not making payments in full or on time. Remember, child support takes priority over partner support. This means that if there is not enough money to pay both child support and partner support, then the payor may only have to pay child support. For more detailed information on this topic, visit cplea.ca/family.